Okay, good afternoon, everyone. This is Judge Lopez. Today is February 26th. I'm going to call the 4:30 p.m. case, Sorrento Therapeutics, here on a few motions. There are about 220 people on the line, so I've muted the line. If you know you're going to be making an appearance today, I'd ask that you please hit 5-star, and I will unmute your line. Once I've unmuted your line, I would just ask that you please just monitor yourselves, make sure, because once I unmute you, I'm not going to mute you one more time. So why don't I take appearances in the courtroom, and then we will start with folks on the line. Who wishes to make an appearance first?
Good afternoon, Your Honor. Caroline Reckler of Latham & Watkins on behalf of the debtors. I'm joined in the courtroom with my colleagues, Mr. Harris and Mr. Gordon, and on the video is the debtor's Chief Restructuring Officer, Mr. Medji.
Okay. Good afternoon to all of you.
Good afternoon, Your Honor. John Kane of Kane, Russell, Coleman, Logan. Also with me in the courtroom is Joe Coleman on behalf of Jackson Walker.
Okay. Good afternoon.
Good afternoon, Your Honor. Mark Schinderman of Milbank. On behalf of the Creditors Committee, I'm joined by a couple of colleagues online.
Okay. Good afternoon. Mr. Duran, good afternoon.
Good afternoon, Your Honor. Hector Duran with the Department of Justice on behalf of the U.S. Trustee. With me is V&A Garza from my office.
Okay. Good afternoon to both of you.
Good afternoon, Your Honor. Sherry Hyan of Greenberg Traurig on behalf of the Official Equity Committee. And joining me this afternoon is Andrew Glenn of Glenn Aguirre. He's on the line. Thank you.
Good afternoon. Okay. Anyone else wish to make an appearance in the courtroom? Okay. Well, let me turn the folks online. I'm just going to go in the order in which I see them. Here's a 212 number.
Your Honor, this is Mo Megchi, the CRO.
Okay. Good afternoon. Here's an 832 number.
Good afternoon, Your Honor. This is Tim Culberson, representing myself, pro se attorney.
Good afternoon, Mr. Culberson. Let's see. Just going up and down the line. Oh, there's one more. Here's a 908 number.
Good afternoon, Your Honor. Andrew Glenn for the Equity Committee, Glenn Ager, Brooklyn, and Fuentes.
Good afternoon, Mr. Glenn.
Good afternoon.
I found another one. Here's a 646 number.
Yes. Good afternoon, Your Honor. Justin Rollins of Paul Hastings for Vivasor Inc., the proposed debtor, DIP lender.
Good afternoon. Okay, I believe I have covered everyone on the line, and there's about 260 people now on the line, so I've muted the entire line. I will check again in a minute to see if anyone wishes to make an appearance or be heard on a matter, but for now, I believe I have covered the courtroom and those online. So my case manager has informed me, Mr. Culberson, I think you asked to go, I think it makes sense to go before the DIP motion, consideration of that, and I'm going to let them. I'm going to take that up, and why don't I take that up at this time, and then I'll take up the DIP. Mr. Duran?
Yes, I have some preliminary comments about that.
What's the preliminary comment, Mr. Duran?
We're concerned about today's hearing on Mr. Culberson's motion for sanctions and stay of asset sales at ECF 1887.
Mm-hmm.
We're taking no position on that motion today. As a result of any evidence that may be adduced, the court may make findings of fact and conclusions of law that may prejudice my client, the U.S. trustee, regarding his motion to transfer venue or to dismiss these cases.
I think Mr. Culberson wants me to dismiss these cases today. He's shaking his head, yes. He asked to go. He wanted to go. I'll give you a fresh crack at it. I'm not going to, you can take it out, but I'm going to take this up today. He asked for the hearing. He'll have it today. If you want a fresh crack at it, maybe you can bring new evidence to the table. I don't know what Mr. Krubberson's going to present today.
We're going to bring our evidence and argument before the court on March 11th.
Okay.
And in the alternative, we would just ask that the court make findings of fact and conclusions of law only to the extent of Mr. Culberson's allegations and his.
I think that's fine, but let's see where this goes.
Thank you.
Okay. All righty. Mr. Culberson, let me turn things over to you, sir.
Your Honor, can you hear me okay?
Just fine.
Okay, as a preliminary matter, just what was discussed with Mr. Duran, my understanding was my motion to transfer venue and dismiss, which was filed first, was set for March 11th as well. My motion today is dealing with the motion for sanctions as well as to stay any sale proceedings in this matter. So I'm glad to take up the motion to dismiss and transfer as well if you want me to. But I asked for an emergency hearing on that, but I was set to wasn't told that I could get that done. So
is that right?
I just want to.
Right, but I thought we had set a couple of motions for today, the ones that he asked for. What were the ones that you asked to go for on today, Mr. Culberson?
The one set for today is my motion for sanctions under 9011, as well as a motion to stay any sale proceedings based on that.
Okay, so those are the only things that you want to go forward on today?
Yes, Your Honor.
Okay, I just wanted to make sure. We can keep everybody's powder dry then on the connection with the motion to dismiss and the motion to transfer venue. Okay? All right, counsel. Mr. Culberson, how do you wish to proceed?
I'd like to go ahead and pre-admit my exhibits except for Exhibit 6. So I just want to make this as efficient as possible. I will not be offering Exhibit 6. Everything else I'm asking the court to admit, subject to any objections.
Okay, and just for the record, can you tell me the docket number just so we have a clean record?
Oh, hold on one second. It's not on this.
Hold on,
paper
I think
copy.
I can find it for you here. You filed he witnessed an exhibit that's at 1919, filed on February 24th.
It's 1925.
19.
There's
a 1925 that has an
amended.
exhibit 11. You talking about the one you filed on the 24th or the 25th, Mr. Culberson?
I believe it was the last filed. I amended it one time, I believe yesterday.
Okay.
It was just
1925.
one exhibit.
So if I were to then look at that 1925, we've got exhibits 1 through 5.
Yes, Your Honor.
That would be kind of just making sure I'm looking at the UPS store docs. I'm just reading the description. UPS store docs, the docket number 1 in 2390084. This looks like the scintilla voluntary petition, screenshot of metadata, screenshot of document property metadata from 2390084, and another UPS store doc. Am I looking at the right ones, Mr. Culberson?
Yes, Your Honor.
Okay. Any objection to the admissions of exhibits 1 through 5?
Yes, Your Honor. This is John Kane on behalf of Jackson Walker. We object to the admissibility of exhibit number 5. It's not relevant, and there is a lack of foundation here. The declarant is not present for cross-examination, but predominantly those pleadings are not relevant. They relate to the Apt Harvest bankruptcy case.
You're just objecting to 5?
Yes, Your Honor.
1, 2, 3, 4, no objection?
That's correct, Your Honor.
Okay. 5, you'll have to prove up. 1 through 4, admit it.
Exhibit 6, I'm not offering. Exhibit 7, 8, 9, 10, and 11, I'm offering, and they're basically just the, docket number 8, Exhibit 7, docket number 1879-1, and cause number 90085. That's the signature bank statement. That's an exhibit, part of U.S. Trustees exhibit to their motion. The rest of them are U.S. Trustee exhibits, docket number 1879-2, which is Exhibit 8. Exhibit 9 is 1879-3. Exhibit 10 is 1879-4. These 3 documents, exhibits 8 through 10, are simply statements from public documents from the California Secretary of State. and then docket number 711 is Exhibit 11, and cause number 239008, Statement of Financial Affairs for Sorrento, which was filed in this matter.
So 7 through 11 at this point, you're not doing 6, right? You're going to do 7 through 11, is that right?
Yes, Your Honor.
Okay. Any objection to 7 through 11?
No, Your Honor.
Okay. So I'm admitting documents 1 through 4 and 7 through 11. Okay. How do you wish to proceed, Mr. President?
All right, Your Honor, I would like to first start out by saying 57 hours before the scintilla petition was filed in this matter, there was no bank account, no scintilla asset, and no P.O. box, no basis for venue. 57 hours before this case was filed. I'm asking for monetary sanctions under Rule 9011, which can be imposed against any attorneys if their pleadings are signed and filed for any improper purpose. According to the U.S. Supreme Court, manufacturing corporate citizenship facts, as was done in this case, is fraud upon the court and fraud upon the law. That's the Miller and Lux case. And fraud upon the court and fraud upon the law is an improper purpose. I want to share a timeline with you that I think will be illustrative of what we're dealing with here today in terms of form shopping, in terms of manufacturing venue facts by the attorneys in this matter. I want to start by pointing out, and I want to, if I could share my screen, Your Honor, that would be, sure. I can show you some exhibits.
Yeah, I'm going to make you what we call the presenter. Something should pop up to give you authorization.
Okay.
Your Honor, this is John Kane. Just for clarification, I want to see, is this an opening statement, or are the parties going to have an opportunity for...
Everybody's going to have an opportunity. I'm just going to let him present his case in chief.
Thank you, Your Honor.
All right. Go ahead.
Can you see this, Your Honor?
Yes. Yes.
Okay. All right. So June 1, 2015 is the date Scintilla Pharmaceuticals was born in Delaware. June 8, 2015 is the statement and designation by foreign corporation filed by the company soon after being incorporated in Delaware, where their principal place of corporate address or principal place of business was 6042 Cornerstone Court West, Suite B, San Diego, California. Then we move forward. There was business activity. I think this is public record. August 15, 2016, Scintilla acquires pain specialist Simner for $200 million while they're based in San Diego, California. The other significant business activity for Scintilla was November 9th, 2016, when Scintilla acquires a majority share in Silex while based in San Diego, California. These facts are important when we talk about citizenship. June 27th, 2022, we have filed by the corporation, or a document filed by the corporation in the state of California, dated June 27, 2022, before the filing of this bankruptcy, at least 8 months, about 8 months before the filing. Principal place of business, or the principal address filed with the Secretary of State, was 4955 Directors Place, San Diego, California. Now, fast forward to February 10th, the afternoon of February 10th. Latham and Watkins has in their exhibits, exhibit number 1, which is an email thread between Latham and Watkins, Jackson Walker, and Stretto to set up a $60,000 transfer from Sorrento to Scintilla to a signature bank account that was presumably a Houston account, which we believe was not a Houston account. But that doesn't even matter for purposes of what we're talking about here, because the motivation behind this entire scheme to get this case in the Southern District is right here on page 5 of 6 of Exhibit 1 for Latham and Watkins. This is an email from Veronica Polnick on February 10th, 9:56 a.m. We're talking less than 72 hours before the filing of this case, they're asking for a $60,000 checking account for Scintilla to be set up, and she tells Drew with Sorrento, who's the agent performing this task, as always, we need a Houston account, but you know that. And then she loops in Christy Peguero from Jackson Walker, Matt Kavanaugh from Jackson Walker, and Liz Freeman, who we've talked about extensively in past hearings, who was at the time having a romantic live-in relationship with the then presiding judge, David Jones. Now, why does this matter? Because this is the beginning of the scheme to create a fraudulent venue in this court. Then, literally within less than 48 hours, Veronica Polnick, the same attorney who sent this email to Drew saying we need a Houston account, but you know that, she goes to the UPS store in the Woodlands, Texas, close to where she lives, and I'm trying to get to the top here. Sorry about moving these documents around.
Take your time.
This is the UPS store document. This is my exhibit number 1. And this is filled out by Veronica Polnick, attorney for Scintilla. For Scintilla, she actually puts the correct address of where they're located at 4955 Directors Place, San Diego, California. And then we can tell the time of when this was set up by the credit card receipt at 3:07 p.m. on February 12th. So less than 48 hours after we've got a $60,000 checking account set up solely for the purpose of making sure they had what they conceived to be an asset that they could lasso this case into Texas with. And then she goes to the UPS store to get a bogus P.O. box principal place of business address at the UPS store at 3:07 p.m. This is less than 10 hours before they file the petition. Then at 4:17 p.m., this is easily verifiable, self-authenticated. All you have to do is download this document number 1, put it into any type of Adobe, right-click, look at document properties. Josh Gordon of Latham and Watkins creates the voluntary petition for Scintilla Pharmaceuticals it's at 7:28 p.m. But first, before he does that, he signs, I think it's down here a little lower, he signs Dr. G's signature at 4:17 p.m., and that is exhibit number 3. And that's page 15 of exhibit 3. He signs the signature of Dr. G, not claiming he didn't have authorization to do so, because apparently he did, or he wouldn't have signed the board of directors authorization to file the bankruptcy petition in the first place. That was at 4:17, literally 1 hour and 10 minutes after the bogus P.O. box is set up. Then at 7:28 p.m., he then drafts this petition. So literally within hours, we've got this entire scheme to get this case, to circumvent the venue statute, to get this case into the Southern District. Then we already have established this by the prior hearing, but at 12:48 a.m., Matthew Kavanaugh of Jackson Walker files this petition at 12:48 a.m., again, less than 10 hours after the P.O. box is set up. And what do they represent in this petition? They represent that the principal place of business for Scintilla, who has been admittedly inactive for several years, and the only major activity it's ever had is in California, and that it was set up in Delaware, and everywhere you look in the record, you're going to see principal place of business in San Diego, yet here in this petition, they incorrectly and intentionally placed Switchbud Place as the principal place of business. Not only that, but then at the bottom, and I'll talk about this a little more in detail, they check the box that they've complied or that they have venue because the debtor's domicile or principal place of business or principal asset has been in this district for 180 days immediately preceding the date of petition or for a longer part of such 180 days than any other district. That's not quite exactly the rule. That's not quite the language from the rule, and we'll look at the rule in a second. The other important post-petition facts is there was a meeting of creditors on May 30th, 2023. In that documented meeting of creditors, Mr. Medji is asked on page 4 of Exhibit 2 to Jackson Walker's exhibit list. Mr. Medji is asked, and Scintilla Pharmaceuticals Incorporated is a wholly owned non-operating subsidiary of Sorrento Therapeutics. His answer was yes. Where are the headquarters located, Mr. Duran asked him. And he said, in San Diego, 4955 Directors Place in San Diego. That testimony was on May 30th, after this case has been on file for months. And the CRO, who actually is in the shoes of the CEO, is saying that Scintilla is headquartered in San Diego. Absolutely proving that was a falsehood that's put into the petition. But then it gets more interesting. We move down to page 26. And this time, Mr. Kelly, the associate for Ms. Tomasco, who was representing Nat Cell at the time, was asking questions, follow-up questions, where Mr. Medji had already admitted that the address was in San Diego, basically the headquarters. And then Mr. Kelly asked Mr. Medji or Ms. Paricki, where is Scintilla's principal place of business? And instead of Mr. Medji answering that question, Ms. Reckler knows she's in trouble. So she steps in and says, I can answer that question. This is Caroline Reckler. Scintilla has a post office box in Houston, and it has a bank account in Houston as well, and its principal place of business is Houston. That is an inaccurate, and I'm trying to be kind here, but that is false. And it was proven false, demonstrably false, just preceding that in the testimony, but Mr. Medji was not allowed to continue that line of questioning because Ms. Reckler had to step in to fix it because they knew they were in trouble with that questioning. And then we have in June of 2023, the state of California documents show that Scintilla still filed another statement of information corporation dated June 29, 2023, where they say that they are principally located, their principal address is 4955 Directors Place. They don't put 7 Switch Bud because that's nonsense. And so as we look at the venue statute, let's look at what the venue statute says. And I must admit that, like many statutes, they're not written very well. But it says, a case under Title 11 may be commenced in the district court for the district, in which the domicile, residence, principal place of business in the United States or principal assets in the United States of the person or entity that is the subject of such case have been located for the 180 days immediately preceding such commencement, or for a longer portion of such 180-day period than the domicile, residence, or principal place of business in the United States, or principal assets in the United States of such person were located in any other district. So we know there are 2 ways to comply with the statute. And these lawyers tried to cover both bases, but they didn't do a very good job of it. The principal place of business is established by law by the U.S. Supreme Court in Hertz v. Friend. And this court is well aware of that case. This court has presented on this case. And that case stands for, there's a nerve center test when you're dealing with principal place of business of a corporation. But that doesn't fly here because there is no nerve center in Texas. So what do they have to do? Now they're backtracking the law, or they're trying to twist the law by briefing in I think it's the 1900 docket number 1900. They talk about, oh, well, we're a non-operating company, So therefore, we can use the last activity factor that's talked about in Harris, and then they misapply Harris, and I'll demonstrate that in a minute. They misapply Harris by saying that they get the benefit of the last activity, and they do so by saying, well, that checking account that we set up in that email thread, when we're talking about getting Sorrento to set this up 57 hours before the filing of the petition, that is a bona fide business activity of Scintilla to trigger the last activity factor under Harris. But here's where they get it wrong. In the Harris case, the holding, let's talk about what they say just before the holding. To adopt a rule that the place of an inactive corporation's last business activity is relevant to determining its citizenship for subject matter jurisdiction purposes, especially where that activity took place in its last principal place of business, is perfectly consistent with the total activity test. But you notice how they said, if it says the last activity took place in its last principal place of business. Of course, in this case, no one's going to disagree that one of the principal places of business had to be San Diego, but the last business activity that they're claiming gets them venue here, simply it's in Texas. It's not in the last principal place of business in California. They go on to say, a rule that the place of an inactive corporation's last activity is always determinative of its citizenship for diversity purposes, however, has the potential to produce the odd result that an inactive corporation may be held to have its principal place of business in a jurisdiction in which it would never have been held to have its principal place of business while it was active. That's the key language. What debtors want us to believe is that checking account was the last business activity to establish citizenship for Scintilla in Texas, but that would produce the odd result that the principal place of business was somewhere other than where they were based when they were last active, and we know they were last active in California, not Texas. Then they go on to say, surely Congress cannot have intended to produce this result either. And then they say, therefore, we hold that while the place of an inactive corporation's last business activity is relevant to determine its principal place of business, it is not dispositive. That's what they left out of their briefing, Your Honor. And I'm sure Your Honor knows that as well, just by reading their briefing to see the gaps in their logical argument in applying this case. And so they don't have that principal place of business in Texas. They knew that. That's why they're sitting here scrambling in the creditors meeting to try to cover that up, to try and confuse things. Don't let Medji answer that again, because he's already answered it truthfully once and got them into trouble, and they saw it coming. And then we go on to let's look at what's been represented since then. Since this case was filed, well, actually, this was before the case was filed. Miss Veronica Polnick, one of the lawyers in the case, who was instrumental in getting the checking account set up, says that Scintilla's place of business is in San Diego. Then in document 711, this is a little bit hard to read, I apologize, but it's SOFA 25 attachment, page 35 of 37 of document 711. It says the other businesses in which the debtor has or has had an interest. It lists the business name, Scintilla Pharmaceuticals, and the address is not 7 Switchbud Place, The Woodlands, Texas, P.O. Box 513. The address is what it really is. It's 4955 Directors Place, San Diego, California. And then finally, as I stated before, Mr. Medji admitted under oath. Where are the headquarters located? Where's the brain of this operation? At 4955 Directors Place in San Diego. There was only one board of director in Scintilla. That was Henry G. He was the CEO, the same CEO of Sorrento. That's where he resides, the brain of Scintilla. That's the principal place of business. Then we get to the principal asset. They think they can escape this scheme by arguing that the checking account was manufactured. Or, I mean, the checking account, it was manufactured, but that the checking account gets them off the hook. But here again, we go back to the email from Veronica Polnick to Drew Lockard. Why would she be asking that this checking account have to be a Houston account? There's no other reason. There's no other reason than they had to manufacture venue. That's what they were doing just hours before they filed the petition. And it wasn't just Polnick. She wasn't the only one involved. We look at this email thread, because I went through it pretty quick a minute ago. When she asked for the checking account, that's February 10th at 9:56 a.m. Drew Lockard responds and says, as soon as we get the information, we'll send over the wiring instructions. Then Christy Peguero is copying the Latham team and refers Caroline and the Latham team to see the request flow. Then we have another request with everyone involved, all the parties that are involved in this scheme. All in this email. And then they loop in Veronica again to this thread. I mean, you can see all the actors right here. No one's blameless in this. And then we have, finally, at the end, we have Veronica Polnick thanking everyone for getting this done, and they were passing the wiring instructions on to the bank. That's what we see here. That's what's happening. And it's a practice that renders the statute 1408 void, because if this is allowed to happen in a case like this, there's no. They might as well just rewrite the statute and say a debtor can file in any district they want to, because if you allow this to happen, a checking account can be set up 57 hours before the petition is filed, and one can go to any district and file and put $60,000 in a bank account in that district and say they have an asset there. Now, every case they've cited interpreting 1408, every one of them, including In re Handel, In re Frame, all had actual real comparisons to make in that 180-day period. In other words, if a debtor lived in a state for a certain period of time, but also lived in another state for a certain period of time, they compared those actual time frames. So, but here we have an asset that apparently they're saying never existed before the 10th of February. 3 days. So they only want us to look at the 3 days and say, well, 3 days is longer than 0. So therefore we get to have the case in the Southern District. But that's not what the law intended, nor is, because to have that interpretation written statute void, and the legislature never intends to write a statute that would be, when applied, would be void and negligible. And finally, I would say a fair way to look at this is that the asset was in the account of Sorrento of the 180 days.
Mr. Carpenter, you broke out at the last. Mr. Carpenter, I'm so sorry to interrupt you.
Oh yeah.
You kind of went in and out at the last second. And I wanted to make sure I heard every word you said. You said in the last thing. No. There's nothing. You didn't do anything wrong. There's about 310 people on the line, so the system is getting stressed a little bit, which is completely fine. You said one last thing, and if you can start there, kind of with your last point, I think I could hear you.
Thank you for letting me know where I left off. A fair way to look at, I think the way you look at this checking account asset, one way to look at it that would harmonize the statute is that so I'm not sure if you're hearing me.
Well, you said the checking account, and then you went out. I apologize. Can you start again?
Yes. So the asset is the cash. Okay. And so the fair way to look at this is that the account that was set up, the cash came from Sorrento.
There's 300 people on the line.
Yeah, I don't have much more, Your Honor, but it's important.
No. It's important that It's important that I hear every word that you're saying. I want to try to reduce the number of people that are on the line. I'm asking law firms if you're listening. Mr. Corbison, give it a shot.
Yes, Your Honor.
Okay. Talk to me about the cash, the last point again. I think we may be able to get there now.
Yes. So the cash is the asset. I think the better way to harmonize the language of the statute and the
Yeah, I just need you to do it.
Okay, I'll try again.
No, not you. I was talking to. When the line gets to about 300 people, the system tends to overload. It happens in all the large cases. I want to have robust participation. Go ahead, Mr. Corbison. I think we're down to a manageable number now. For that, I know.
Okay, thank you, Your Honor. Again, a fair way to look at this. Are you able to hear me when I hear feedback, or is that when the audio goes out? Probably.
That's when the audio is going out. There's still about 280 people on the line. It's frustrating.
Your Honor, if you could give us a second, I'm trying to get the debtor advisors onto one line.
Yeah, what I'm going to do, Mr. Corbison, I want you to stay there. We're down to 273. Mr. Corbison, I only want you to hit 5-star. The only party I want to hit is for you to hit 5-star. I'm going to hang up, and then I'm going to bring everybody back in.
Okay. So call back in?
Yeah.